Hey, hello, everybody. I'm really delighted to see that many of you wanted to join us today. I am Sharon Levine in Kalamazoo with the law firm Levine and Levine. I'm introducing Mark High with the law firm Dickinson Wright. Alexis Lupo and Mark have worked extensively on materials regarding the Corporate Transparency Act. Alexis was unable to join us today. I'm going to go ahead and kind of introduce folk and get us going because it's a short hour and there's quite a bit of materials to cover. And I want to also be able to manage some of your questions. I want to particularly take a moment thanking Mark and Alexis for the materials and for participating in the program. And I also want to make note and thank Colin Ritzema of Forts Legal, who's been our producer and broadcaster and helped us put this program, bring it to you today live. And so they are terrific and have helped the business law section and the state bar generally quite a bit over the last few years. I'm going to turn this over to Mark so that he may give us some introductory comments. I have and begin the program via the materials that he's written that you have access to. And I will be keeping track of your questions. Please put them in the chat. And if I don't get to your question, please give me a little bump and a reminder, but we will try to get to them and provide any other data that you need. The program is being recorded and there will also be a transcript of the questions. And so hopefully if there's somebody else you know who wants to participate or is interested in this, it can be passed on and should probably also be posted on at least the business law and maybe even the real property section sites. And with that in mind, I'm going to turn the transponder clicker over to Mark and let him get us going.
Okay, well, thanks, Sharon, for organizing this, and thanks, Colin, for making it happen. Thanks, everybody, for being a part of this. Appreciate the business law section, the privately held business forum, putting this together, and appreciate the other sections, real estate at least, being a part of this. So great to see you. Yeah, I do want to say a couple of things about Alexis. It's great that she has been a part of this. The state is a very big part of the act, and they do have responsibilities under here that we'll get to. I am missing having her with me here today. She knows those things, but we'll soldier on, I guess. She had a new baby a week ago, so she's got other things to do, and it's really a special time for her, and so please bear with me as I take on the role of two here. But she's really been critical to this. So let's see, is this going to work? Oh, there it goes. I guess it just takes a minute. Okay, technical difficulties out of the way, maybe. So the Corporate Transparency Act was part of the National Defense Authorization Act, adopted at the end of 2020, vetoed by the former guy, but passed over that objection by the Congress on the 1st of the next year, 2021. This was not a big piece of that 1,000-page act or whatever, so it sort of did sneak in under the radar. This does have a history going back 15 years ago or more, trying to address money laundering problems around the world, coming up with anti-money laundering approaches, really coming out of the Panama Papers and those sorts of things, made it a popular or brought the subject to the awareness of the general public, but governments had already been working to address this problem for many years. Really, the 1989 G7 summit had a task force on international monetary controls, policies, and out of that conference came the undertaking for countries around the world to adopt something like this. So we are a little late to this party. Other countries have have had this for a number of years with various levels of stringency. I think in Brazil, everybody has to report the beneficial owner of all the companies. We are sort of in the middle with the sort of 25% threshold. Canada does have an equivalent reporting requirement. I think that their filings are searchable by the general public. I do need to look into that. That's not true in the U.S. As we'll see. So we have been, as I say, talking about this for a while, really pushed by Senator Levin and introduced originally by Senator Levin and Senator Obama in 2008, as you see there. It focused on the formation agents or the CT corporations of the world to report, and the Secretary of State to collect that information and keep track of it. Ann Baker, who was the head of Corporations Division at that time, resisted as president of the Secretaries of State or Association or whatever as an unfunded mandate that it really put a lot of responsibility on the states without providing any ability to actually do that. So there was a few exciting years there. I have a little story about running into Senator Levin at a Memorial Day parade, but that's another story. We thought this was gone with Senator Levin's retirement. Turns out that's not the case. It did come back in a much different format and has been adopted. So now we have to work with it. So the basic requirements, and we'll go through each of these elements over the next few minutes, is that it requires reporting companies to register personally identifiable information of individual beneficial owners with FinCEN at the U.S. Department of Treasury. So it seems simple enough, but what does this mean? Well, let's start with who has to report. What's a reporting company? The statute specifies corporations and LLCs and other similar entities organized by filing with the Secretaries of State or equivalent office or tribal government. The rules added specifically limited partnerships and the various permutations of those. I will just say that this does include PCs and PLLCs, so doctors and lawyers, professionals are subject to this if they can't find an exemption. The accountants are not, however. They've got their own exemption, and we'll see that. So maybe they've got a better lobby. I don't know.
Mark, I'm going to interrupt one moment. I just want, and probably you're about to get to that, but I do want to make specific note here that if you've got single member LLCs or sole proprietorships, which for a lot of small business folk is important to know, they are not required to file.
I might say that we need to look at a single member LLC because it's a sole proprietorship for tax purposes, but it does form itself with a filing at the state. So I think an LLC with a single member is probably subject to the act.
Oh, so when you refer to sole proprietorships at the bottom of this page, you're referring to what's filed in the counties.
Right. Yes. The excluded are partnerships, general partnerships, and sole proprietorships. They're not formed with a filing at the state level. They just sort of exist or as you say, file at the county level. And maybe that's the point, is that those individuals are known because they have made a filing. But yeah, there's a distinction between having filed at the state and not. And a big piece here is that second last point, that non-U.S. entities qualified to transact business in the U.S. are subject to the act. So that's you can't form in Panama and set up a business over here and start trading in apartment buildings or whatever without filing. They would be captured by this. So those are the reporting entities in the first instance. Then we get to what exemptions there are from having to file. Who are the exempt entities? There are 23 separate statutory exemptions. So I've grouped a bunch of them together here. Generally speaking, they're regulated industries, or otherwise people can figure out who owns them. The second point there is the large operating company exemption, it's called, and that's one that we will spend a lot of time on going forward. Other exemptions, governments, accounting firms registered under Sarbanes-Oxley, nonprofits, I guess on the theory that if they aren't making a profit, they're not very good for laundering. So laundering money, so they get a pass here. And
So Mark,
entities, yes.
We do have one quick question here. So even though nonprofits might file with the state, the Secretary of State, they are exempt?
Yep, they have their own specific exemption here in the 23, the list of 23. So
okay,
clearly
terrific.
Take a look at what that language says. But I think the theory is that nonprofits don't need to be a part of this.
Terrific, thank you.
So yeah, quickly, the dormant entities is a little tricky and very precise. So I don't think we'll even go through that. If you have something that's just sitting there and hasn't done anything and has less than $1,000 in transactions in a year, maybe maybe you don't have to file. So you might look at that. So let's walk through the elements of the large operating company exemption. First, you have to have at least 20 full-time employees. So if you meet each of these three things, then you're exempt from filing. 20 full-time employees using FTEs as the IRS uses it, and independent contractors don't count. You can't consolidate across affiliated entities. So sometimes you can, sometimes you can't use affiliated entities for these tests. In this case, you can't. So that's a pretty stringent number for a lot of smaller companies. Second element you have to meet is to have at least 5 million in gross revenues. This can be consolidated with affiliated entities and is based on the prior year's tax return filing, so won't be available for new entities because they haven't filed anything yet. And interestingly, it's not indexed for inflation, so this will reach more and more companies as we go forward in time here. And then the third piece you need to meet is to have a physical presence in the U.S. It has to be exclusively owned or leased. You can't use a shared office space. The WeWork places, for example, doesn't count as a physical presence. Interestingly, a residential office seems to be okay. So if you can fit 20 people around your dining room table, that can be a physical presence for this purpose. So that's where a lot of the action is going to be in determining which companies meet that large operating company exemption. As I say, with new entities, they can't establish that large operating company exemption, even if you expect to go gangbusters at the outset. All new entities, unless they meet some other exemption, will need to report initially 30 days after receiving notice of their creation or registration. That's not a problem in Michigan. Our state is very good at telling you that within a couple, 3 days that you've been filed and you can start your count right then. I guess in other states, it's more of a problem as to when you actually were put into effect. So this is what we're going to be facing starting January 1st for all new entities, is deciding whether to have to file or not. That last point, how to establish exemptions, I think I've got an answer to that one, which is really good. In the new proposed rules on the form that is going to be used for the filing, it does say that exempt entities are not required to file. So you don't need to file to say, hey, I'm IBM and I'm a public company and I don't have to file. So that's really good. If you claimed an exemption or had to file and then want to claim an exemption because you popped over the size test or something like that, then you would have to file an update to get your exemption. But if companies are exempt, they don't need to file. It's sort of self-executing in that respect. So that's good. So who has to report? You have to, the beneficial owners of these reporting companies, their information needs to be reported. And so a beneficial owner means an individual either exercises substantial control over the entity, again, we'll go through these, or owns or controls 25% or more of the entity. They're looking here for the ultimate individual owner or owners of these entities, of the reporting companies. You go up the chain, sort of looking for like the ultimate parent entity in a Hart-Scott situation. You want to find the natural person who is ultimately owning or controlling this company. So the form will allow you to have different layers reported as you go up if it's held by a holding company, and then you have to report the owner of that. So it would be a little tricky, I think, but that's what they're looking for. So let's go through these in a little more detail. Substantial control, a person exercising substantial control, means a person serving as a senior officer. It says specifically secretaries and treasurers are not a senior officer. Or you have authority to appoint or remove a senior officer or a majority of the board, or you have substantial influence over important decisions, or any other form of substantial control over the reporting company. That's a little vague. And again, these would be, well, maybe 10% owners or 20% owners that don't meet the 25% test, but still are substantially in control of the company. Those individuals would have to be reported, have their information reported. So that's the substantial control side. On the 25% of ownership piece, the statute says undiluted ownership interests. I think that means in our language fully diluted. You just sort of work through who owns all the shares and all the different classes, and see if you have 25% at the end of the day there. Different tests for corporations versus LLCs in terms of 25% of what. It's either vote or value. If you've got, so does that mean a preferred share that doesn't have a vote but has some preference on a distribution or something? Does that count? LLCs are more on a capital and interest basis. Maybe that's easier, but it gets more into accounting. And so this is, going to be challenging, and we'll see how this all rolls out over the next, we still have 8 months, 10 months until this kicks in. So we expect to get more information as we go along here. But yeah, there are going to be challenges in terms of companies with multiple classes and people with waterfalls and people that have voting rights that kick in only upon a default or something like that. It's going to be exciting. And then this does point out that trustees and beneficiaries can be beneficial owners, even though they might be acting on behalf of a beneficiary. A trustee can still be seen as having to report their individual information. I don't know, Sharon, you wanted to talk about that here, or do you want to do that a little further?
I can talk about it very briefly here because there's already been a question about it. It's very interesting. And when there's a couple of simple story problems that came from the rules. And so the site for the rules is in the materials, and you may want to try to take a look at those. They do elaborate on several of these points. With regard to trustees and beneficiaries of trusts, the final rule does identify the trustee, first of all, as the individual who is deemed to control trust assets for purposes of determining which individuals own or control 25% of the ownership interest. So the liability or the responsibility falls on the trustee, which I thought was fascinating. And then the final rule also identifies circumstances in which ownership interests held in trust will be considered owned or controlled by the beneficiary. And so this warrants a good close look, because if the beneficiary is the sole permissible recipient of income and principal from the trust, or if the beneficiary has the right to demand a distribution or withdraw substantially all of the assets in the trust, then they are the ones who have that ownership interest and constitute a beneficial owner, which is fascinating. The other thing that that will come up here in a little bit about other exemptions has to do with modifications, for instance, in a probated estate or in a trust, when the beneficiaries might assume the interest in the company. And that is, from what I can read, at least so far, is after the settlement of the estate and after the interest has passed. At that point, the clock starts to tick for the requirement to upload that reporting, to upload the report. So this is something that I think is going to be really relevant and of interest in any changes in business succession plans or in real estate transactions, obviously, and of course in the estate planning arena.
It's entirely possible. It's entirely possible that you're going to have three different people reporting the same 25% ownership interest: the trustee, the beneficiary, if they have the ability to call that in or get the money from it. And as that last line there says, even the grantor, if they can revoke the trust, they're still in control. Yeah. So there's going to be some overlaps here.
There are going to be overlaps. So had you touched on the creditor's rights yet?
That's right here. There are 5 specific levels of individuals, types of individuals who are listed as being exempt, not having to file, not having to have their information reported on a beneficial reporting company. If they own solely for their employment status, if they're an individual acting as an agent or a custodian, if they're a minor, although the parents would have to report, an individual with only a right of inheritance without actual ability to pull that in. And then creditors with a right to receive or enhance payment do not have to report if they're just holding the security, the interest as security, I guess.
So let's talk very briefly about those 3 pieces: minors, right of inheritance, and creditors, just to give everyone a little bit of an asterisk to this thing. When the child attains the age of majority, at that point they are required to report, assuming they fit the definition of beneficial owner. If you only have a right of inheritance, again, we come back to that whole probate or trust administration. If I'm the beneficiary of a trust, not necessarily, or the beneficiary under a will, I obviously don't have to. But once that estate is settled, I think there will be that obligation. Finally, it was very interesting to me about creditors, because doing so much business work where perhaps people have security interests, or they're not necessarily, from what I can gather, required to report. But I do think that potential stock options might raise that. And of course, the minute that somebody forecloses on an interest or exercises their rights under a security agreement, I think that they're going to have to look real hard at filing. There's 2 questions here that I would raise that I would like to just report up and see, Mark, if you have any particular thought, or, just to indicate that, yeah, we agree with you. One is it safe to say that mandatory tax distributions would not result in a finding of control? I don't know. I would think it might be
That's a
safe.
distribution, so yeah,
But yeah,
it
it
gets
is
you
a distribution.
25% of the company's income. I think that's a problem.
And then the employee with stock options, that's another really interesting question. Mark, any particular thought on that?
Well, yeah, that goes back to the question of what the fully diluted term means, or as they call it, an undiluted. So that's got to be played out. I think again, they're looking for people that are trying to hide money and get it used. I guess an option person would say, well, I haven't put my money in yet, but they may still have, maybe you fall under one of those other control tests where okay, you have options to buy half the company, and you haven't done that yet, but you're still appointing the president, or you are the president, or something. So yeah, you got to look at a lot of different factors for each person.
Well, that brings us to a couple of simpler story problems that are on the next, I think on the next page. Yep. And these were taken directly from the final rules. And so you've got the reference to the site for you if you pull them up and go take a look at it yourself. And just very briefly, you've got a husband and a wife and a son, each own 1/3 in the corporation. The son serves as the president. One spouse is the COO and the remaining spouse is general counsel. And the answer that the government gives, or that they gave in the rules, for instance, is that that George, Winona, and Sam would be the only beneficial owners, but they are all beneficial owners. If Sam steps down but maintains his ownership role and his brother James is named president, then James also becomes a beneficial owner. So that's one, what we would call an easy example, but does show you some of the complexity that you have to think about in this kind of a problem, in this situation. And then on the next,
that one's, I think, one of the easier ones, but
yeah. I mean, all of us here are already thinking about a whole bunch of different ones. In this next problem, Sarah and Skylar are 50-50 owners in a company. Sarah's the president, Skylar's CEO. There's no other officers. Nathan becomes a manager for more than 40 years, but he does not have what the government would deem to be a beneficial ownership, because he does, I would say, not have substantial control. Mark, any comment or thoughts about that?
I think this is going to be a real common situation where you have a couple of owners and somebody actually operating the business day to day. Sort of a fine line, I suppose, as to what that person, what their authority really is. This gives us a $5,000 test for writing a check. That seems pretty low in a company that might have 15 million in sales. So if that president can, or manager can sign $15,000 checks, is that a different story? I guess we'll have to see.
Well, Mark, this is really interesting. We have a question here that says, if you're in doubt, why shouldn't you just report? What's the benefit of hunting down an exception? And is reporting unnecessarily complicated or intrusive? Well, the government would claim it shouldn't cost you more than 20 minutes and $80, but should this just not be a matter of standard part of operations going forward? That's an interesting question. I don't like to give that much information to the government, but what do you think, Mark?
Well, I think you'll see that the information you have to give isn't very great, really, and what you're providing is something that the government already knows. If you provide your driver's license, some part of the government knows that already. So is that a real secret? You give that to the hotel clerk when you check in every night. And the access to the information we'll get to in a couple of slides. It's only available to a very limited sort of law enforcement world. So I'm a calm person who thinks that, yeah, maybe the easiest path here is to just fill the form in and send it in and then forget about it until you need to update it.
Mm-hmm.
Others might take other approaches.
I think that sounds reasonable. If people are comfortable in that, with that, and to err on the side of caution potentially. Okay.
Yeah, there are penalties involved, and we're coming up to those eventually here too. So
yeah.
So this is what you have to report. If you decide to report, you have to tell about the reporting company, its name and trade names, and its current address, and its tax ID number. And foreign companies have different requirements there if they don't have a US ID number, although if they're doing business here, maybe they should. And then you have to report each beneficial owner and each company applicant. Now, applicant's a word we haven't used before, and that was a little scary for a while. We'll talk about it in a minute. But for each person, you need to give a name, a date of birth, residential address, and a unique identifying number from a driver's license, a passport, or you can apply to get a FinCEN identifier number. So that's something that especially lawyers or legal assistants or somebody that does a lot of formations may want to go through that process. And that's the subject of proposed rules right now too. We have seen these reports. That's the subject of a proposed rule. Now subject to comment. Comments due March 20. It's only going to be online. Filing is only going to be online. It's like 58 lines or something. And there's a lot of, for each line, you can put in an unknown. So that it makes it tempting to say, well, I don't really know who that person is or what their address is or where they are. However, somebody at the end of the day, at the bottom of the form, is going to have to certify that what is on there is true and accurate. So I'd be a little careful with just defaulting to clicking unknown as you go along the way. This company applicant, this was exciting for a few months. An applicant is the person who files the application to form an entity or is primarily responsible for directing or controlling the filing. So, you know, in a word, incorporators, organizers are going to have to be one of those reporting persons on a beneficial owner, on a reporting company's filing. The final rules made clear that that's true only for newly formed companies. So, you know, our concern was at the outset that an applicant, to somebody that incorporated a company in 1940, we're going to have to find them and get their driver's license number or something, which seemed daunting. That's gone away. And so we don't have to go back in time to find applicants. Existing companies will have to file, but only to show, to list who their existing beneficial owners are. And then new companies, starting in January 1st, will have to file and report their owners and the applicant or applicants. So if client calls me and says, I want to start a company, I say, that's great. I call Rochelle and I say, get that the articles filed. We'll have to report her name and information and my name and information because I directed her, and not the intervening people, not the secretaries that maybe type up the form or messengers that walk it in, whatever. So this is still going to be a challenge and does put some obligations on us as forming people, but it's not as bad as we thought it was going to be there for a while.
Mark, I have a question here. Do you think that that for a lot of lawyers who do file articles and on behalf of their clients, that they should just go ahead and get a FinCEN number? Is that what you're even suggesting in the prior slide?
Yeah, I think that's right. That we'll see what that process looks like, but I expect it's and how long it'll take to get approved, if there's such a thing as approval, but it will prevent, it'll be easy, I think, to put in your number 62438 rather than each time putting in your address and your ID number and uploading the picture of your passport or whatever. I think if you do this more than a few times a year, that you might as well just move forward and get a FinCEN number when those are available.
Great.
So stepping back to big picture, how are we doing on time here? I guess we're doing good.
We're doing great.
Yeah. So the reporting company is the one that's going to file, and somebody's got to certify, as I indicated before, that the filing is accurate and complete. Beneficial owners don't have to file. It's the reporting company that is the filing entity and needs to track those people down. Is the applicant obligated to file? There's maybe a reporting requirement that I think is too obscure to go through now. It really all falls back to the reporting company and finding an officer or somebody that's willing to step up and find that information and fill out that form and click the box that says it's all true and complete. So when is this to be filed? So we've indicated before, new entities, this kicks in January 1st of next year, the end of this year. New entities formed after that date will have to make their filing within 30 days after being created. Existing entities are going to have to file too before the end of next year. If you're formed now, you've got a year. So I think that'll be a pretty exciting process come October, November of next year as you get, I think the government estimates that there's 32,556,929 existing entities that are going to have to file between January 1st and December 31st of next year. So I guess you don't want to be first, but I wouldn't want to be the 32 millionth one either. This is going to be an exciting time. Again, compliance is going to be focused on the smaller companies because if you meet that large company exemption, 20 employees, 5 million in sales, and a physical location, you don't have to file. But that still leaves a whole lot of mom and pops to think about driving home tonight, the pizzeria, the dry cleaner, single practitioners, doctors, lawyers, whatever, that don't have 5 million in revenues and 20 people. That's a lot of filings that are going to need to be put together next year. And a lot of those people, I don't know how they're going to even know about this. So thank you for being a part of this and helping spread the word.
Well, I think it's important too, because many of our very small clients, mom and pops, even have a hard time understanding that they have to, we just went through a raft of them, right? Filing their annual reports. When they distinguish between getting an EIN from the government and filing their tax returns and getting their licenses and filing reports and keeping their records up to date, which is woeful. Now this is one more piece of paper that we're going to have to help them distinguish between being federal versus state and what they need to provide. So that's why I think this is so important for us as lawyers to understand for our clients right now.
Yes, and it's to a certain extent it's going to be get it done and you're finished, but there are it's not really one and done. If things changed, you've got to file an update. You have to file a correction after changes occur. New owner, existing owners move. That's exciting. If you, as I indicated, maybe filed before because you qualified, but now you've come to an exemption, then you need to file to claim that exemption. Vice versa, if you fall below the number for a year, maybe you have to file and then file 2 years later if you get your sales back up again, and then any inaccuracies need to be fixed. So you do have to monitor the process, educate people that as things change, if they add a daughter as a shareholder, that may change the reporting requirements.
Well, and so if you have a sale of interests in real property and the makeup of the limited liability company for the ownership of the real property changes, again, that's going to require an update. And also, you know, I suppose if you're processing an estate or a trust administration and you have modifications and changes, you need to keep your eye on that as well. It's and then what do you do about the circumstances where you have incremental purchases and sales of stock interest? You have to keep, I would imagine you have to keep your eye on when you get over a certain threshold of a new shareholder who was at 20% one year, but is 25% the next year. You think that would also have an impact then, Mark?
That would be a change that would need to be updated. I don't think going from 25 to 30 would be a change. You're already over the 25 level. So I don't think you need to report each individual purchase. Just if a person becomes a 25,
right,
or then they need to be reported and then wait for the next time when the change happens.
We have a question here. If the company applicant under slide number 22 does not apply to existing entities before effectiveness,
yeah,
how does this fit with slide 24 that an existing entity created before 1/1/24 must file? Let me.
Well, the entity has to file, and the existing entity has to report its beneficial owners, but an existing entity doesn't have to report its applicant. Doesn't have to say who formed it in 1958.
Got it.
But it does need to show its current beneficial owners. So an existing entity does need to. They want to know, you know, if Putin already owns a company. 25% of a ice cream store.
So if we formed an entity here this year in 2023, we don't have any obligation to file, but by year end.
Not this year, no, that's true.
But by December 31 of 2024, that existing entity will need to file a report. Is that what you mean?
Yep, that's exactly right. And they
but
would.
Then if I, as the lawyer, filed the articles on behalf of the client in 2023, and then I'm no longer representing that entity, and by year end 2024, it's up to the entity to make that filing. Is that what you're suggesting?
Yeah, it's always the entity's obligation to file. An existing entity formed today, reporting next year doesn't have to report its applicant because it's already existing. A new entity's formed next January would have to file quickly then, 30 days after formation, list its owners and its applicants.
Okay, maybe that helps folks make that distinction.
Yeah, and this brings to mind, of course, those dormant entities that are sitting there and then suddenly spring to life. That would be okay. Now I need to file for them, even though we didn't before.
Right.
Okay, there are penalties here if this isn't followed. It's willfully can bring up to jail and big fines, $10,000. So somebody's got to step up and be prepared to again file that report and say it's true and accurate. So you know the willfully maybe is helpful, but clearly folks that know about it and don't make that filing or make inaccurate filings are subject to getting caught. So definitely something that we want to push compliance on. So who has access? We alluded to this before. It's a very limited universe of people that can look at this. It's not open to newspapers and the neighbors and whatever. This is done to collect information about bad actors. And so who wants to know about bad actors? It's law enforcement. And to see if somebody is putting money into this country that shouldn't be here. Interesting that financial institutions will have access for their know your customer purposes, but they'll have to ask the client to give that consent for them to have access to that. Chase doesn't automatically get access to the full database. So again, this is subject to one of the three proposed rules. And so if this is something that you're concerned about, I'd find that and make some inquiries and file some comments if you want. So that's an important piece. But like a Hart-Scott, it's not open to everybody. It's just to limited folks for a limited purpose. So just sort of, I guess, reviewing where we've come from and where we're going. Adopted the 1st of January in 2021. The rules at that point, the regulations required that it was all going to be in place within a year. Well, that did not happen. The final rule didn't get issued until September of 2022, almost 2 years after adoption. So they're definitely behind on when this was supposed to kick in. I mean, think about FinCEN, however big that office was, suddenly trying to get ready to accept filings by 132 million companies. That was a challenge, I expect. So probably not unreasonable to think this would take longer than they anticipated, but we are coming to the end of the grace period here, and it will kick in January 1st for the new companies newly formed after that date. And the existing companies all have to file next year too. As I say, there's 3 rounds of rulemaking and process on the form and access to the information, and then the procedures for getting the FinCEN ID number. I expect those will all be solved yet this summer, and in time for an update on this at probably Business Law Institute in October. I hope that you'll all come along to that. A good event in any respect. So this does raise some issues for us as attorneys. It's a lot less concerning than it was when we thought applicants applied to existing companies. But there's still issues about whether you should be forcing people providing information about clients. It is the obligation of the company to make the filing. So that's I don't think we're going to be making filings on behalf of somebody, but we need to tell them that they should be doing that. And if they don't, I'm not sure that that's going to be our problem, but I guess we'll see. I mean, there still are issues, clients that you formed last year, but aren't involved with anymore. Clients that are sitting here that you haven't talked to in a while. Should you reach out to them? Are they going to say, "Hey, I didn't know about this. You should have told me about this." But again, it's less concerning because it really is the beneficial, the reporting company's obligation, and not ours anymore. I certainly would put in practices, and I guess we'll get to this. So I'll hold on that until then. This was Alexis's slide. The state does have obligations under the Act to notify entities at formation and around annual filings that this requirement exists, and then provide access to the reporting materials. Maybe that's just as simple as a notice that goes out with the annual report that the state sends out every year that includes a link to the reporting form. So we will get assistance from the state to tell people that this is out there.
Well, that's really interesting, Mark, because one of the questions that we have is what is considered a dormant company for purposes of being exempt from reporting? And I wonder, do you think that means a company that's become inactive by failure to have filed its annual reports? Or do you have a definition in from your perspective of dormant?
Well, I think that's one element. There is a definition, and I don't have a cite for it, I'm sorry, in the rules about what an inactive entity means. Certainly not filing reports would be an indication. but we all know companies that haven't filed their annual report for a couple of years and move along just merrily along their way. And if they there are monetary limits, as I say, I think it's $1,000 transaction by a company in a year, makes it undormant, even if they aren't registered with the state anymore. Yeah, it's intended to be broad brush, capture a lot of people.
Well, you know, it's interesting because we do have to keep in mind that it is a one-time report, unless, of course, you've got significant changes. It's not like having to file an annual report every year like a company does with the state of Michigan. So there is that, I suppose.
Mm-hmm.
One of the other questions that we have here is, are there any thoughts on whether accounting firms, CPAs or accounting firms, can provide advice to clients on whether the reporting requirements or exceptions apply, or assist them with complying with the filing requirements? Is this, that's interesting. They're asking, of course, is this considered legal advice that law firms should provide, or will CPAs probably do it anyway?
Well, interestingly, I was approached last week by the Michigan CPA Association to give this presentation to them. So they're aware, they're concerned, they're interested in learning about it. Their advisors, they are, close to the financials, so they'll know if a company meets the 5 million test, for example. Is it advice to say, is it legal advice to say, well, there's this obligation that you should look at, and here's the requirements? I think they're probably giving a lot more legal advice beyond that in terms of structuring transactions or whatever. They are certainly aware of it and will want to know more about it. And maybe that's a good reason for you to call the client and let them know before the accountants do. Saves the accountants from an unauthorized practice claim.
The next question that's coming up has to do with this page here, and that you've just changed to, which is the expectations for potential changes in the House. I'll let you opine first, and then we could talk about this question that just popped up. So go ahead.
Yeah, well, if all this wasn't scary enough, and we dodged a bullet with the applicant issue being limited. There's a movement afoot to have lawyers take more responsibility for the entities that they're forming. And there was a bill passed in the House last year, defeated in the Senate in the last week or two of December, to have a special rule apply to attorneys. I mean, really coming out of the Pentagon, or the Panama Papers situation, that bad attorneys are allowing companies to be formed without fully searching out who's behind it. ABA is trying to head that off by saying, "Oh, don't worry about it. We're going to add our own ethical rule and take this responsibility on ourselves through the ethics rules." That may be too little, too late. Last fall we thought this really was going to start to happen, maybe as early as January. As I say, it was avoided in December with the Senate. New Congress, new world. This is always subject to being adopted again. Would it be adopted in the new House? Hard to say. We'll see if they adopt anything this year. But it doesn't mean that this is going to go away. Either the ABA will put something in knowing it's coming, or B, the Corporate Transparency Act was, as I say, 15 years in the making. So it may not happen this year, this Enablers Act, but maybe next year, 2 years from now, 6 years from now, things are coming. And so that's still possible.
Well, and what's interesting is one of the questions that was raised is, and what about enforcement and auditing? And to me, that means, which political party is more inclined to enforce and audit. We've got a lot PPP enforcement going, Medicare, Medicaid enforcement going. Do you have a sense of that on auditing or enforcement? And we do have about 5 minutes left.
Yeah.
And I have one more other question.
Well, these are regulatory authorities. It's the Department of Treasury, so not theoretically subject to political whims, and maybe more to the point, is subject to having budget to pursue people. So we'll see how this goes. There's a lot of grains of sand on this beach. Which sand grain do they choose to enforce on? I don't know. I don't know if it'll be my favorite pizza place or not, but if it does, if they're gonna find somebody and make an example to bring this to people's attention. So the best idea, I hope, is to avoid the problem.
We have a two-part question here that I think goes really kind of to the heart of what we're trying to help our lawyers understand, and is they want to confirm an existing entity, let's say from 1970, they do need to file by 1/1/2025. Is that right?
Yes, that's right. Unless they meet one of those exemptions, yes.
Okay, and then the second part to their question is, all the beneficial owners for the entity must file, or one beneficial owner?
Well, the entity files and reports those beneficial owners that either own 25% or have substantial control. So,
Okay.
if you've got 10 shareholders, one is a 50% and the others each own whatever the math is there, 10%, then 5%, whatever. Only the one shareholder would have to be reported, their beneficial ownership, their individual information. And then, of course, the officers, if they're in control, that they need to be reported as well.
And we have another follow-up question about Laura emailing notices to the person who files and submits the articles. So in future years, the state notice of annual report being due will be sent to the attorney. I got about a dozen of them who forms and then submits the articles. How can the attorney office get this notice from Laura to go to the client reporting entity without it continuing to go to the attorney's obligation to email the annual report? So that's also going to the heart of the discussion. Yeah,
that's an interesting point, and I expect that where it would go is not to the organizer, but to the registered agent.
Right.
We will ask Alexis that as to how they're going to actually pursue this, but that's the contact person they have. Yes, the articles get mailed back to the person with the name on the top of the form, but their contact going forward is with the registered agent. And it's the registered agent's duty to get the information then to the company. So if you use CT or have an officer of the company as the registered agent, then you can sort of stay out of the middle and let them solve their own problems.
Yes. So it is 4:57, and I just want to field if there are any other questions. Everybody has the materials prepared by Mark and Alexis, and I'm really grateful that Mark was able to come back in and share this with us. Share it with your colleagues, and I really appreciate it. I'm sure there's going to be lots more discussion this year, and we'll look forward to seeing the forms that are going to have to be filed.
Yeah, well, I just want to point out the issues here, which is you can put something in your retainer letters now. You can certainly start adding things to shareholders agreements, operating agreements, bylaws that people are going to comply with these requirements. I think this is really important to start that process now. I've had those in retainer letters and operating agreements for over a year now. So this is really something that, and that's going to be true going forward. So
yeah, it's important. It's important for all of us to deal with it. Thank you very much, Mark, and thank you all for participating this afternoon. It's been it's fascinating, and it's helpful to begin to understand and process this. Thank you also, Colin and Forts Legal.
Yeah, appreciate everybody's attention. It was great fun.
Yeah, great. Thanks, Mark. Take care, everybody. Thank you.